I can't allow you to proceed while you're driving a vehicle.
No, I'm saying I'm parked. I'm pulling up parking now. It seems like you're practicing law from the bench. I'm going to respect your courtroom, but I disagree. Yes.
Sir, you have to stop interrupting.
Penalty and perjury.
If you stop speaking when I'm speaking.
Your Honor, he's coercing. And since there's no statute of limitation for fraud, he's wasting judicial resources. Honor my counterclaim to dismiss this matter.
So based on the proofs on the record, the court does find that.
All right, guys, today we've got one of the most painfully irritating sovereign citizens I've ever seen in court. And we've got Judge Hillman, who actually tried a different approach this time. He chose patience instead of immediately shutting the guy down. So this one is pretty interesting, but let me ask you this. At what point do judges need to stop entertaining this nonsense and just hit these people with contempt? Because personally, I think the judge could have handled this a lot better, but I'm not going to spoil anything. So let's go ahead and dive in and watch this sovereign citizen get completely shut down.
You say I'm driving a vehicle. Yeah, you need me to stop? I
need you to stop, sir. I can't have you driving
give me
while
15 seconds. I can pull it back up to my family house.
No, I can't allow you to proceed while you're driving a vehicle.
No, I'm saying I'm parked. I'm pulling up parking now. I'm parking, right? 5 seconds. Okay, I'm done, Your Honor.
You recall in reviewing your business records if a foreclosure was conducted with regard to this property?
Yes, it was.
Objection, Your Honor, hearsay.
Okay, overruled. You may respond, sir.
On what grounds? So I could maintain the error for the record when I appeal this, if this don't go accordingly?
Okay, it's a business record, sir. That's an exception from
first-hand knowledge. Was he there at the closing table?
Doesn't need to be, sir.
Your Honor, it seems like you're practicing law from the bench. I'm gonna respect your courtroom, but I disagree. I would disagree as tremendous. So, okay. Court reporter, can you please note that the honorable judge, I'm stating he's practicing law from the bench without facts.
But your objection is part of the record, sir. All right. You may continue, Mr. Dooher.
And is this a true, correct, and complete copy of the sheriff's deed of mortgage foreclosure, to the best of your knowledge?
To the best of my knowledge, yes.
And is this sheriff's
objection, Your Honor? Can he vow to that under penalty of perjury? That's the original document.
Your Honor, he stated this to the best of his knowledge.
No, under penalty and perjury, can he contest that that is the original document with the wet blue ink signature? Penalty and perjury.
All right, sir. That's not the question. The question is whether he can identify the document.
Under penalty and perjury, can it be yes?
Sir, you have to stop interrupting.
Penalty and perjury.
You can make an objection, but once you've stated your objection, you have to stop.
Yes, Your Honor.
All right.
And for the record, Your Honor, I do have counsel coming for this next court date. They obtained, as soon as he get back in the country, he will be jumping in to take care of this matter further. So I'll ask if you just give my counsel some time before any permanent decision is made so they can review these books, all interrogatories, so we can make a fair decision. Because I'm not arguing it's a debt, and I've been trying to honor the debt, Your Honor. I'm not arguing that it's a debt. I done did everything possible to honor this debt. They have not been in compliance with it.
And Your Honor, I would object to that, given this would be our third hearing, and he had ample time to get counsel.
Objection again.
All right, let's take one issue at a time, gentlemen. I can't be expected to remember 3 or 4 objections all at the same time. I'm going to overrule the objection on the basis of a business record exception. As to the request to adjourn the matter for Mr. Bay to retain counsel, I'm going to deny that request. Mr. Bay is
on what grounds, Your Honor? Because I never got served directly.
If you stop speaking when I'm speaking, then I will state my grounds.
This is honestly my biggest issue with most judges when it comes to sovereign citizens. They really need to be a lot more firm in situations like this. I mean, this judge seems like a good guy, but he's being way too patient with this guy's nonsense. We all know this sovereign citizen is clearly taking advantage of that patience, and he's trying to drag everything out because the judge isn't shutting it down fast enough. It's like, come on, man, at this point you've got to at least threaten contempt or something, because it's extremely frustrating watching these people get away with this behavior. I don't know about you guys, but it feels really, really obvious that this dude is just playing games with the judge right now. Let me know what you think, and let's dive back and hopefully the judge finally shuts him down.
I
This
never
is the
requested
time.
that. You stated that, Your Honor. This is my first time requesting any adjournment to bring in incredible counsel who can handle this matter fairly on my behalf.
At this point, I don't even see that you have standing to participate in this case, although I guess we will get to the truth on that issue. So,
So, Your
objection.
Honor, you don't have my deed of records right there. You don't have me as the deed owner. You don't have me as a certificate owner in the record. I put all that on the record. So for you to say I don't have standing is kind of unfair from my understanding.
And was that redemption date September 27, 2021?
Your Honor, he's coercing. He coercing Mr. Dewhurst.
Was a government record and or document recorded with the applicable recorder of deeds for this this document?
Okay. Any objection to that, Mr. Bay?
Absolutely objection.
Okay. And what's the basis for your objection?
He's a third-party debt collector. He's not a real party in interest, and he has no first-hand knowledge of any of the affairs that took place with this mortgage or at this closing table. And that Mr. Dewhurst he's not eligible to bind a corporation. Do he have the status of a CFO or a CEO in that company?
Okay. So the objection is that this witness doesn't have the
first-hand knowledge to any other matters.
Okay. All right. So the objection is overruled.
And has Carrington ever conveyed any of their ownership?
Objection, Your Honor. Objection.
What basis, sir?
Rightful owner as the title, rightful owner as complete ownership of the property. Can't just take away my interest like that without facts. You guys still have not had no verification of debt. What you have in your hands, Your Honor, we don't reached out. They cannot verify that debt, and they cannot verify that they ever loaned Rachel Brown and Matthew Brown any money for this mortgage. They can't. They can't prove that, and they haven't yet. And I've been waiting. I just want to know if they're a real party in interest, are they a real creditor in the amount, so we could handle any financial obligation if they are yet to prove that. Like you said, I got the deed, and it's sealed by the county records. I have the warranty deed as well, and it's sealed by the county records. Objection. Can you prove I didn't redeem and attempt to redeem? Can you prove that it hasn't been corresponding and negligence on you guys' behalf?
Overruled.
The property was foreclosed on and Carrington took control of it.
Okay.
Objection, Your Honor. How can you take control over something that...
One thing I seriously don't understand in this hearing at all is why, with everything on the line, this guy thought it was a good idea to represent himself. His house is literally at risk here. And instead of getting a lawyer, he really sat there thinking that spamming objection, like it's some kind of cheat code, was going to save him. That is not how the legal system works. Have you ever heard of the Sixth Amendment? You have the right to an attorney for a reason, because the law is complicated, and YouTube University is not a law degree. I honestly swear these people must be mentally ill to gamble everything just to prove some strange point. What do you guys think? Is there even a single situation where this would make sense? Because after seeing all these sovereign citizen cases, I can't think of one where representing yourself like this would be a good idea. But then again, I've never read their script, so I can't say for sure. Let's dive back in.
I got the taxes in my name. I've been staying there the last year, and I have the deed and the warranty deed again for the record.
May I ask a question that would help?
You may, Mr. Johnson.
Objection, Your Honor. He's about to coerce him again. The question was clear. He could answer that on his own.
Your
He
Honor,
said he had 30 plus years of experience. This shouldn't be his first rodeo. He can answer that on his own.
Was there any redemption made by any party during that time?
No.
And none of your reflect.
Objection.
None of your record.
Objection.
And once again, you have not.
What's your objection?
That's not
Mr.
credible.
Bay?
That's not credible.
Sorry, this is not your time to ask questions, Mr. Bay. Mr.
Okay,
Johnson.
let me know when I'm credible to ask questions.
All right, Mr. Johnson. Any other questions?
Has Carrington ever conveyed ownership of the subject property to any party?
No.
Thank you. No further questions, Your Honor.
Objection, Your Honor. Matthew Brown, not the owner at the time that they
Mr. Bay, this is your time to ask questions. So if you want to ask any questions to Mr. Dewhurst, you may ask questions to Mr. Dewhurst.
Okay, Mr. Dewhurst, is it not law that 15 USC 1692G requires verification of any debt?
Your Honor, I object as to relevancy.
Again,
what's the relevancy, Mr. Bay?
I'm establishing bounds for fraud. And since there's no statute of limitation for fraud, I'm going to make sure if they're not the original creditor, that it's fraud.
You didn't respond to the relevancy or how this is relevant.
The relevancy of 15 USC 1692G, it binds any corporation or anybody who's saying there's a debt or a balance to verify it.
Okay. So this is the time to ask questions, not to argue law.
No, I'm not trying to. I'm asking a question. That was a question.
You have a question regarding the facts for Mr. Dewhurst. Okay, you may proceed.
Yes. So again, Mr. Dewhurst, under 15 USC 1692G, do you have to verify a debt?
I'm going to have to object again regarding relevancy, Your Honor. This is, unfortunately, he does not have standing to bring any claims of verification.
Objection. I'm a real party in interest. Objection, Your Honor. He doesn't have any standing. He hasn't proven he's more than a third-party debt collector yet.
Your Honor, after the foreclosure period ran,
Your Honor, we don't know if this is credible foreclosure. Can I ask my questions, Your Honor?
All right, gentlemen, you cannot speak at the same time.
Next question. So, Mr. Dewhurst, are you conscious of the verification of that letter that been sent to your company twice, that I sent with behalf of Matthew Brown and Rachel Brown, that they're yet to respond from? My notary sent it. The notary republic sent it.
Your Honor, I would have to object.
Yes or no?
Sir, you have to let Mr. Johnson state his objection. Mr. Johnson, what's your objection?
Your Honor, she's asking the witness to respond to a vague request if he has any notice, but I would ask that he would only ask as it relates to the business records, Your Honor.
Objection, Your Honor. I sent that to the business and record department, and I sent it attention to the CFO of the company.
That's an argument. That's not a question. This is a time for questions.
Does anyone else think it's about time this guy gets a lawyer seriously? I'm cringing watching this, and honestly at the judge too. Because at what point do we just call it and say, please, for the love of everything legal, give this man a contempt charge for wasting everyone's time? He has said objection over 30 times already, and not a single one of them has made any sense. It's literally like he thinks if he says it enough, the court will just give up and let him win. Contempt exists for a reason. It's meant for people exactly like this who refuse to follow courtroom procedure and do nothing but stall the entire process. At this point, he either needs to be hit with contempt or given a competency hearing because something is clearly not clicking here. But what do you guys think so far? Would you have thrown him in contempt by now? Or would you just let him keep cooking up this random nonsense? And also, if anyone knows how many times he said objection so far, let me know.
No, that was in the form of a question. You didn't let me finish, Your Honor.
Okay, well, you can't ask multiple questions within the same question.
Okay. Well, Mr. Dewhurst, what was the problem answering the verification of that letter? If you have that in the record. So we've been asking for the original.
Objection, Your Honor. He stated that he was not aware of a letter.
You're right. Correct. So I should say then, moving forward, is there a problem producing the original contract with the wet bluing signature from Rachel Brown and Matthew Brown? If you have that in the records.
Okay, so you have a question for Mr. Dewhurst?
Yes, Mr. Dewhurst. Is it fair to say you cannot prove that the original, you don't have access to the original copy of the note of the mortgage?
Yes,
under penalty and perjury. Do the company have it, Mr. Dewhurst?
So you may ask another question.
And also, Mr. For you, Your Honor. So it's also credible and fair to say he has no firsthand knowledge of anything as well.
Okay, so that's an argument. That's not a question. Okay. So yeah.
All right, I'm learning. I'm sorry, Your Honor. Thank you for your patience. So Mr. Dewhurst, under penalty and perjury, can you confirm that your company followed all GAP procedures with this process?
Objection, Your Honor.
So I guess the last question, again, I just want to confirm that Mr. Dewhurst, you have no firsthand knowledge of the of Carrington Mortgage being the creditor in this loan for this mortgage. So that's still kind of broad, Your Honor. I want for the record for him to say, are you guys the creditor, or you're not you don't know?
Asked and answered.
No, that's not asked and answered. I'm asking directly. Mr. Dewhurst, is Carrington Mortgage, can you confirm they're the creditor of this loan or this note, or you don't know? And I'm asking you that for lawful reasons.
And so by bidding the highest in the sheriff's sale, what interest does that give Carrington then in this proceeding?
We're then the creditor.
Okay. All right.
Allegedly. So that is true if that's the case. But if Your Honor or court, if Carrington can never prove they ever issued anything, is it fair or is it lawful to state that they never have the right to say they hit with the highest bidder with anything?
Any more questions for Mr. Dewhurst, Mr. Bay?
Not at this moment, Your Honor.
Okay.
Not at this moment. I'll let my counsel deal with that.
Okay. Does the plaintiff rest?
Yes, Your Honor. But if I may just conclude with a couple things, if that's okay.
Well,
objection, Your Honor. Statement and brief from counsel is sufficient for summary judgment.
And to show that there was indeed a foreclosure sale conducted on March 25th, 2021.
Objection, Your Honor.
And this is final argument, so that you can't object to that.
I'm sorry, Your Honor.
All right. Additional final state arguments, Mr. Bay?
Yeah, again, Your Honor, you know, he's wasting judicial resources.
The plaintiff is wasting the court's time. Are you serious right now? I honestly can't tell if this guy is genuinely one of the dumbest people alive or if he's just trolling the entire courtroom for fun. Because, sir, you are literally the one dragging this whole thing out. The judge, the attorneys, the court staff, everyone is stuck there because you refuse to follow the rules. And we all know exactly why he's doing it. He's just trying to stall things out, hoping that somehow delaying the inevitable will magically make his problems disappear. The court isn't just going to forget about your case because you wasted enough time or said objection 100 times. And that's the thing with these sovereign citizens. They love screaming about their rights, but they conveniently forget about responsibilities. It's honestly funny to me because the law is very clear. If you file nonsense, refuse to follow procedure, and waste the court's time, that's on you. But accountability clearly isn't in their vocabulary. Just like a lot of other words, let me know what you guys think. Is this dude completely clueless, or is this all just one big game to him?
With this, because again, I have proof on file and on record, correspondence. We try to resolve this matter. At this time, I would like to bring my counsel in. They'll be back in the States in a couple of weeks. And also, Your Honor, can I request that Mr. Johnson put his bond on file? Can I get his bond information, his liability bond for this matter as well?
Okay, no, that's not an issue in this case.
I ask for you to just honor my motion, honor my counterclaim to dismiss this matter, because they don't have, nobody with real party and interest on this line right now. Nobody with firsthand knowledge is on this court case right now that can speak and contest to what's going on. So with that being said, I ask to adjourn this matter or dismiss this matter because for failure to state a claim upon which relief can be granted.
An individual who's identified himself by the name of Amate Bay claims to have a possessory interest in the property, though he did not present any proof on the record today of any interest that would make him have standing to contest this mortgage foreclosure and this suit for possession. So based on the proofs on the record, the court does find that Carrington Mortgage Service LLC does have the right to possession and therefore a judgment of possession against Amate Bay and all occupants of the premises is granted.
What is my time frame to no, can you just for the record, so there's no contract with Amate Bay and Carrington Mortgage in this matter, right?
Sir, I'm not going to explain my ruling to you. I just ordered that the Carrington Mortgage would have the right to get an order of eviction, removing all occupants from the premises.
That's fine, Your Honor. I'll make sure it get overruled in a higher court. Thank you.
Okay. All right. That's all for the record. Thank you, gentlemen.
Thank you.
Your Honor. Have a nice.
Yeah, this guy is definitely mentally unstable, and I'm not even joking. There's just no way he honestly believes this is going to work. And the funniest part of this whole situation is when he looked the judge straight in the eye and smugly said he'll just appeal it and get everything overturned like it's some guaranteed cheat code, bro. That is not how appeals work. Appellate courts don't just rewind the case and let you start over because you didn't like the outcome. They only look at legal errors. Not, I didn't get my way. Mistakes. So unless the judge actually violated your rights or ignored real laws, you're just wasting more time and money. Reality is about to hit this guy hard. And honestly, the judge probably should have hit harder too. I know I'm tough on judges, so tell me if I'm wrong here, but I really feel like the judge should have laid the hammer down a bit more. But regardless, this whole thing was a masterclass in what not to do in court if you ever end up in a legal battle. Do not take notes from a sovereign citizen. Even though I was critical of the judge, the amount of patience he showed was honestly wild. But at the end of the day, the law isn't going to bend just because someone refuses to accept it. Sovereign citizens can argue all they want, but the legal system doesn't care about their made-up rules. It's like arguing with gravity. No matter how many times you say it's fake, you're still going to hit the ground anyway. Guys, I'm going to wrap it up here. Let me know in the comments what you thought about this guy. Was he just trolling the court, or did he actually believe he had a chance? And if you enjoyed the video, don't forget to like and subscribe for more content I post every single day. Stay tuned, and thanks for watching. Take care.